Welcome to the Litigation War Room, where you will hear great stories and great insights to raise your litigation game and win more cases. Here's your host, litigation attorney, Maxwell Goss.
JJ Conway, welcome to the Litigation War Room.
Hey, thank you, Max. Thanks for having me.
Well, I am thrilled to have you on the program. Now, listeners, you might think class actions are only for law firms with large case budgets and armies of attorneys. But our guest today, JJ Conway, has built a very successful national practice while running a small, independent litigation firm. In this episode, we'll talk about a case that JJ brought that helped change how autism treatment is covered, and another that took on pension fund abuse during the Kwame Kilpatrick era in Detroit. JJ also is going to share how he evaluates class actions and how he manages them with his lean operation. So, JJ, can you just start by telling us a little bit about you and the work that your firm does?
I followed a pretty traditional course for a lawyer in Michigan. I went to a local law school, U of D, here in the Detroit area. And then after that, I went and worked a year at the Court of Appeals. And after that, I worked in commercial litigation for about a year and a half. And then I was about 27 years old, and I had an opportunity to kind of branch out on my own. And so I started working as a solo practitioner at 27, and I was handling primarily employment cases, non-competition agreements, things like that. And then I was still in my 20s when I realized there was this untapped area, which was employee benefits. It was an area of law that was overlooked, as is pretty much the case. Big companies always had representation. They had plenty of people that were willing to, help out companies, but there were very few people practicing on the employee side. And it wasn't just the employees, it was all of their families that were affected by these benefit plans. So I saw an opportunity and kind of shifted the focus of the practice. And I have been practicing in the area of employee benefits litigation ever since.
Okay, and I know that class actions are a big part of your practice. How did you start doing class action work?
Well, I didn't start out with the idea that I would be doing class action litigation. These are largely contract disputes that were discrete issues affecting employees and their families. But what you started to see in the trend lines with employee benefit litigation is that if it was a generic problem with a plan, so if there was some kind of an issue that wasn't unique to the person themselves, that this could, because these benefit guides were given to, hundreds, thousands of employees, and sometimes in the area of healthcare, we could be talking as many as 1 million people could be holding that contract, that this issue, if it came up, would have sort of broader application. And so I sort of stumbled into it. And I realized in a case that I was just handling for a family that this could have bigger implications. And from there, I figured I better talk to some people who practice class action litigation to learn a little bit about it. And they said, "We think you're onto something here with this." And that was my intro to it.
And the rest is history. Okay.
The rest is
history.
history.
Yeah, good. Now, when you and I chatted before the call, we talked about a number of interesting cases that you've handled. A series of them, actually, I think, related to autism treatment. Could you tell us a little bit about those?
Well, it may be a little bit hard to believe today because we've gotten so much more advanced in our treatment of children with autism, and the ability to find access to healthcare for children with autism is much more prevalent than it was. But going back 20 years ago, that was not the case. It wasn't the case at all. First of all, people were trying to get a handle on why there was a spike in cases, what was possibly causing this. And then what was also clear is that there weren't really any good treatment options for children with autism. They were trying to sort of get special education in the schools, and there were other things that were being done. People were doing things in home to have treatments for their kids. And so Beaumont Hospital was sort of out front, University of Michigan was too, in trying to create treatment centers for children with autism. And they would bring in medical doctors, pediatricians, psychologists, trained people that were able to work with the autistic community, and they would provide a course of treatment that would help these children. It was intensive and it was expensive. And so not surprisingly, insurance companies started denying access to that care. And so that was sort of how we started looking at that issue.
So interesting. Tell me more about the supposedly experimental nature of the treatments and how that figured into the litigation that you handled.
Well, it started out with one case, and it was a remarkable client. It was a father who was really an exceptionally good salesperson. And he had a son, and some of the signs were there that the child was developing a little differently than his other son. And so he started, trying to seek out opinions about what was happening. And it was determined that the child had autism. So the next thing he did is he figured out, well, what do I do for my kid? Where do I send them? And so he found the Beaumont program, and he started seeing real gains for his son. He started seeing some real change in his ability to sort of take care of himself. He was becoming a little bit more independent. And he was just flabbergasted that they would deny this care. He was under the supervision of a pediatrician. They had PhDs on staff working with these kids. So he said to me, I want to challenge this, but I want you to go learn all this. I want you to go and spend the day with my kid and watch all this happen and get educated on this. And I want to take these guys on. And so it was so unusual for me. Usually, the client comes in the office and that's it. Maybe we see conference rooms with depositions, but I'm in this little treatment center with all these little kids and I'm watching this thing. And he had lined up experts and he sort of got me schooled in this. And so we kind of with him behind it, he was the propulsion behind it. We took that case on, we won the case. The exclusion was struck down. And then he said, well, I think I have a lot of other families that are going through the same thing. Would you talk to them? And so we did. And then sure enough, it was hundreds of families.
Wow.
And then we started bringing these cases to take it on as a big issue.
What was the result in the case with that original patient?
So the original patient, that was an individual case. He was not actually a part of the class action, but they won their case. Yeah, this guy, he had the patience of Job. He was really unbelievable because his policy was what they call a self-funded policy, and he worked for an automotive supplier that ended up going bankrupt. So he had to go and chase this thing down in bankruptcy court, and he ended up getting paid. I mean, he just saw it through, and he never was deterred. And that kind of helped, get the rest. He was a lot of very positive energy when we took them on a class-wide basis.
Okay, and that was really my understanding, the first case of its kind?
That was the first of its kind. And from that, and I think one of the things that you were talking about before is, how do you do this if you're kind of a small practitioner? I mean, we've had various times up to 2 associates, not a very big practice with a practice manager. And so if you want to get into this space, you're going to be punching above your weight. You have to. And so we partnered up with other firms that were very well capitalized, had larger staffs, could put a lot of people on the case to do the hard work of a class action. And so, if you will, we were sort of thinking up the theories and then collaborating with other lawyers and then bringing these cases. And that's how it got going.
Yeah. So interesting. And I know you you went on to handle several class actions, and there was one in particular dealing with military families. Can you tell us about that one?
So what was happening was the first crop of cases, and this was all the major insurers in the United States, most of whom we ended up suing, but they were denying care for children based on the notion that this was an experimental treatment. It was not proven. And they were using old studies, they were using outdated studies, and of course this had changed over time. There was a time when sort of almost all therapies start out experimental at some point, but they cross over, they become more mainstream, they've been tested. So that was one crop of cases. The military's healthcare plan, which is known as TRICARE, had a unique issue all to itself. It was a totally separate issue. And what they had was they were paying for autism treatment, but they were paying for it only if you were active duty. If you were retired military, it was an exclusion in your plan. Now, when we think of retirements, just lawyers and that, retirees are in their 60s or 70s or whatever. Retirees in the military are sometimes in their 30s. These are young people. And so you had this whole group of families that had children with autism. They had served our country. They were part of the military's healthcare plan. And yet they were just sort of getting second-class treatment, for lack of a better. It seemed totally arbitrary. So in that case, we brought the case against TRICARE in Washington, D.C., and it, as happened with a lot of the autism cases, there was sort of a unique resolution of it. It didn't have to go all the way to a judgment or a settlement. There was an agreement that they would change their policy, and all of these families that were affected, and there were tens of thousands of them, were suddenly able to have the care.
Wow. Wow. Okay. Well, that's an amazing result. Have these autism cases, the benefits cases relating to autism treatment, is this still raging on, or have these died down as insurers have changed their policies?
Well, it was funny. We used to talk internally. While we were doing this and litigating the issues, there was a pretty broad movement nationally to change policy about the treatment of children with autism from a legislative perspective. And you may have heard of Autism Speaks, a very well-known lobbying organization, a public interest organization. They had sort of crafted legislation that was model legislation to take around the United States and to have this adopted within all of the different states so that coverage for these types of treatments would be mandatory. So while we were going on, we sort of figured eventually these cases will stop by operational law. There's going to be a law on the books. But it was, when you went back and looked at it, there was a whole group of families that just totally lost out.
Yeah.
There was a whole group of families that were really going to benefit once the legislation took effect, including families in Michigan. But there was this crop of people in the middle. They had the claims. We had this issue going on. We were winning these cases, but they weren't going to benefit from the law yet. So that was essentially the group we were representing.
Okay. Now, shifting gears a little bit, I know we're not going to be able to cover every different case and every kind of case you've handled, but I know you handled an influential case concerning pension funds for the Detroit police and firefighters. How did that case come about?
That is part of kind of Detroit's tough history with the bankruptcy and the very difficult effects of Mayor Kilpatrick's administration, which had some pretty harmful effects on city workers. Just sort of explain this issue in a quick way. People that work for private companies are covered by a law called ERISA. And ERISA gives regulatory oversight to the Department of Labor. Pension funds are monitored. They have accounting procedures. They have to produce their financials. If their funding levels drop, they are put on a watch list. The Department of Labor is monitoring them. All the people that are in the pensions kind of know this. State governments and city governments aren't covered by ERISA. And they actually fought to not be covered by that law. As a result, it's the Wild West. These pensions really don't have any kind of regulatory oversight. And if you don't have honest government, they can be a source of some pretty bad behavior. So in that particular case, Kilpatrick and his cronies came in, and he had a number of appointments on the pension board. They had come into some money as the result of issuing bonds to shore up the pension funding. And these guys came in, and some of their fellow trustees, and for lack of a better term, they kind of just stole the money. They took it. And it caused a real funding problem. Frankly, had the biggest impact on why Detroit went bankrupt. And so we sued them for their behavior managing the pension funds. And it was a pretty long and dragged out case. It went to the Court of Appeals, and we won there too. But it was a tough case.
Yeah. Can you tell us a little bit about litigating the case? What hurdles did you face?
The first thing was, and I will say, one of the issues in a class action is there is so much work that's done before anyone even knows it's getting filed. I mean, you have to vet these issues because this is going to be a very expensive, long-term proposition. And you've got to kind of know where you stand. I mean, you've got to know that you've got a fighting chance on the law before you launch one of these things. Because the worst thing that happens is you go all the distance, go the distance, you have a case certified, and then you lose, and you've cost, tens of thousands of people a claim. So you really want to make sure you're on solid ground. The biggest obstacle in Detroit was governmental immunity. Is all of these trustees were immune. They were government people, and there's a law in the books that says they cannot be sued unless they were essentially reckless. And we looked at these deals, and we thought, I gotta say, this looks reckless. I mean, it doesn't. They were wiring money into hedge funds that had no capital. They were getting into these strange real estate deals with their friends, and they didn't own properties. And it was just, they looked bad. And we thought a judge is going to be able to make that call. A judge is going to be able to say these trustees were not abiding their fiduciary duties and they were reckless. And that's what happened. The courts found that the trustees had abdicated their fiduciary duties and it harmed the class. And I will tell you this too. It was not a hard case to make to a judge because there was sort of a moral outrage about this. The workers that we were representing were from the class reps, were from the water and sewage department. I mean, these were hardworking people that were, in the sewers of Detroit, taking care of the city. Well, these people were stealing their pension funds. And I think there was just kind of even at the Court of Appeals, there was just sort of an outrage about the way that they had been treated and that they could get away with this. And the courts put a stop to it.
Wow, that's amazing. So the case did go to trial?
The case ultimately settled after they had a right to appeal because it was governmental immunity. They had the by right to go and have the Court of Appeals look at it. And after that, after they lost that issue, we were remanded to the circuit court. And this was kind of interesting when you talk about governmental immunity and what a big hurdle that is. And people that practice and get involved in government litigation know how tough it is to make a governmental immunity case. We had one deal in particular worth millions of dollars that the court granted summary disposition in our favor that there is no way this could have ever happened and been a good deal.
Yeah.
So once that happened, the dominoes kind of fell and we went into, a multi-day mediation. The case was resolved.
Okay. Can you tell us about the settlement?
Well, it's all public. I mean, there was several $1 million that were replaced to the pension funds that was provided by their insurance companies. The trustees were insured. But one of the interesting things that came up during the process was that this was not going to be a one and done. This wasn't going to be something where you just settled off a case, put some money into the pension funds, and then moved on. There needed to be real structural reforms. And what had happened was it turned out probably on the order of 15 to 20% of these pension funds were invested in unregulated investments. So something you couldn't buy on the stock market. These were private investments. And after the settlement was reached, it was agreed that no private, that is alternative investment, could be approved unless it was scrutinized by an outside independent advisor. And I think that had a major impact on getting this place cleaned up and getting it on a more solid footing. And I saw the other day, I mean, the pensioners all took a big cut in the bankruptcy. They are going to be getting their first cost of living check now. So, I mean, there were reforms, and I think they did a lot of good in Detroit.
Yeah, that's incredible. That's cool that you were a part of Detroit's transformation, really.
Well, there were some characters in that. I'm not going to kid you. There were some real characters in that case. That was like that case was like an Elmore Leonard novel. It really was.
That's a Detroit deep cut right there. So, JJ, is your entire practice class actions?
So it's probably 20 to 25% of what we do. I mean, we have a standard employee benefits litigation practice where we help people with benefit claims and we handle their claims. The practice is sort of transformed. So we're sort of doing these across the country now, working with local counsel on various issues. But then, as happens every year or so, one big issue will pop up and we'll put together, as I said, strategic partnerships. We'll look at the jurisdiction where it's going on and meet as a team and then bring the cases. But I have a very predictable standard law practice that's going all the time in addition to the class work.
Well, I would love to drill down a little more on your class action experience. What are you looking for and what's your team looking for when you are evaluating a potential class action?
The first issue is, like any other lawyer sort of going through issue spotting with a client, you're trying to figure out whether there's a cause of action in the first instance. And you're looking at this and you're sort of meeting with the client, looking at the documents, processing it, trying to perform some preliminary legal analysis, and you're determining whether or not they even have a case. Then, when you start to look at what the challenge is, and so the autism case, for example, was an insurance exclusion. That exclusion was being applied not to our specific client. I mean, they were technically, but they were applying that exclusion to everybody else. So it requires a little bit of panning out of the case and thinking more broadly, like, how is this affecting not only the client who's sitting across from you, but perhaps their colleagues or their coworkers? And if you see a broader application there, that tends to be the first inkling that maybe this is more than just a one discrete case, that this might affect a lot of people. So that's the first analysis. then the next question is, well, if it does affect a lot of people, how many people are we talking about? Now, the courts say if it's more than 40, generally speaking, and that can change by state, but if it's more than 40, you may have a potential issue where the numbers are sufficient to bring this as a class. But I think most people would say, well, they're not going to bring a case over 40 claims. But if you're starting to get into the hundreds, the thousands, and that, then you're looking at, okay, this is going to affect a lot of people, and maybe we ought to look at it that way. And then of course, it sort of defaults back to the initial interview with the client, which is, are the issues that are going to be resolved going to be the same for all of them? Is there anything about this that's going to be very unique and sort of break up the group? If you find that, then that's probably not a class action.
And then what about putting together, you mentioned earlier that you've got a small firm, a small team, they handle these big class actions all over the country. And you said that pulling together the right team, the right partners is an important part of that process. Can you tell us more about that?
Well, over time, you begin to work with lawyers. You begin to, the lawyers you work well with. You know them in different states. You know them in different communities. And if it's an issue, there's going to be a geographic component to it. A lot of the stuff happens in Michigan, so we have firms that we work with here. But when we go out state, there are other firms that we would work with. And you approach them and see if there's an interest in working together on a case. Usually there is, because if it's been vetted and they know that you've studied the issue, there's going to be interest. And then you work out sort of a division of labor, a way that the case will work, and then you work as a team. And these teams tend to be even though you're all from different firms, they're very cohesive. Everybody's got a role and everyone's doing something, and it's just moving the case, advancing the litigation. And that's the key.
Well, this has been tremendously interesting and insightful. I'd kind of like to tie things up in a bow with a question or two. Class actions. What's one thing every lawyer needs to know about class action litigation?
Well, one thing I would say is that if you're looking at a case, and I know this is going to be, especially if you're a smaller practitioner, and the case, oftentimes lawyers will say, well, I don't know if this is worth bringing a case over. The dollar value might be lower than, I would recommend for litigation. I think the first question I would ask before you close it out or send the client, a notice that this case probably is going to not be cost effective, is to say, is there a chance that there's a lot of people that are affected by this? That's the first thing. So I would ask that. And then secondly, if it looks like it is going to be a class action, is it something that you could handle on your own, or should you get this in the hands of someone who knows what to do with it?
Yeah. I assume most of the time the answer is the latter if you haven't done a lot of class actions.
Right. They do seem to scare people. But they are, you have to understand the courts have been out in front of this. The rules are very, very explicit. Yeah. It's kind of an elegant area of the law because they've got to manage a complex case. The court's in on it. They want to make sure that this is handled right. It's a nice procedure in the right case.
Yeah, well, that's interesting. And then just one more question, because I want to focus in on your niche in particular. Help lawyers issue spot a little bit. What should lawyers be looking for in terms of benefits issues that their clients might be dealing with?
Well, I'll tell you this. This is the only credential I had when I was in my 20s. I never filed a benefits claim under ERISA as a breach of contract case. That is the worst thing to happen to a poor lawyer that doesn't know. They say, oh, it's a contract, my gosh, and they bring a breach of contract. And these skilled opponents on the other side would remove the case because there's federal jurisdiction, right? It's ERISA. And they would pull it into federal court, followed up by a motion to dismiss for preemption. And you would have a case, somebody comes into you with a disability contract and the case was over before it started. It was like a hellscape. I never had that happen. I knew right away that there was something unique about ERISA, and you have to go through this process of, it's all set up. There's a framework for resolving it. But the number one question that a lawyer should ask, and this is an easy one, is the source of the dispute a benefit plan? And if it is, then you're going, because they look like contracts. Mm-hmm. And they are contracts. That's sort of the interesting thing about ERISA. All we are doing is litigating contracts.
Okay.
A lot like commercial litigation, but we're doing it under a framework that is federal. And there's a pre-suit dispute resolution procedure that you have to follow. There's things like that. But the lawyers get into trouble if they don't realize it's coming from a benefit plan. And the easiest way to resolve that is just to ask yourself in the run through of questions, is the source of the right here for the client a benefit plan? If it is, for a private employer, it's going to be ERISA.
If it is, send it to JJ.
Hey, thanks. I didn't know. That was very nice, Max.
Well, tell us, if listeners want to find you and learn more about you and your practice, where can they go?
They can go to our website. It's jjconwaylaw.com, and it tells a little bit about what we do. We have an inquiry box there if anyone has a question. We're usually pretty good about getting back to people within a day, and so that's a source. And we try to have an informative blog with a lot of questions, frequently asked questions about benefits disputes. So there's a lot of resources on there. That blog has been going for 10 years, so there's a lot of material on there.
Well, we'll be sure to put a link to that on our show notes too. So
thank you.
Yeah. Well, this has been fun. It's been interesting. Really enjoyed your stories and your insights. So thanks so much for being our guest on the Litigation War Room.
Thanks a lot, Max. I appreciate it.
You have been listening to the Litigation War Room with litigation attorney Maxwell Goss. Maxwell Goss brings forceful advocacy and creative solutions to trade secret, IP, and business cases in Michigan and around the country. For show notes and more episodes, please visit us at thelitigationwarroom.com. If you enjoy the show, please be sure to subscribe, rate, and review wherever you get your podcasts. Thank you for listening. The Litigation War Room, including the podcast and all website content and social media, is for informational and entertainment purposes only. This podcast does not provide legal advice and does not give rise to an attorney-client relationship. All views and opinions expressed on this podcast belong to the guests expressing them and do not reflect the views and opinions of the Litigation War Room.